Hello class, I'm here with my sample of my contingent retainer fee agreement. And this agreement will be held with between Valerie Victim and Barry Barrister, who's the attorney, made on the day of 15th of April 2017. Okay, in the section of scope and duties, basically what this section is describing that the duty of the attorney to the client and the duty of the attorney to Valerie Victim is to provide legal services for purpose of prosecution against Tammy Tortsfister for assault and battery. The deposit section, this section is just talking about, I'm sorry. In the deposit section here, it tells you that the retainer fee deposit is required at the time the attorney is hired, which money is to be held in the trust fund. The normal retainer fee deposit is $5,000. Such a retainer fee and other payments must be readmitted to the firm administrator for deposit. Cases in which hearing dates are already set pending or otherwise require extraordinary immediate efforts may require a larger retainer fee. So, depending on the case, and the scope of the case, that would determine the retainer fee, how much or how little the retainer fee is. Compensation, this section is just explaining it's understood and agreed that the attorney fee will be deducted first and the client will pay the attorney following the fee services be rendered. And this is just agreeing to Rule 1.5C. It talks about the client agrees to pay the following contingent fee following the fee for the services to be rendered. And 30% of any of all sums recovered by way of settlement, recovery, award, judgment prior to institution law, or 30% of any and all sums recovered by the way of settlement, recovery, award, or judgment without instituting a lawsuit. I'm sorry, excuse me. Okay, so that we know that the contingency is 30% of any money collected after deducting the reimbursements for any accumulated expenses and costs, whether it be traveling expenses, any court costs that are done. The contingency will be collected after deducting all of those fees. If there is no settlement, award, or judgment granted, the attorney shall receive the amount of $0. That's just stating if the case is lost, then the client owes the attorney $0. There's no fee required for that. And expenses, this is where it's just talking about the client should be responsible for all court calls, testimony, depositions, medical records, any outside things that are being done. The legal fees for those are on the client. So any expenses, exclusion of normal overhead, are not included at this agreement, and we will be billed separately. Okay, examples of expenses are delivery services, long distance phone calls, traveling, service faculties, and meals between traveling, meals while you're traveling. Okay, the client will owe the attorney. The client will owe the attorney the amount of $0 if there is no recovery. Which is just letting you know if there's no recovery that the client doesn't owe the attorney any money. It's $0. Okay, the client, by signing this, the client agrees that Barry Barrister will be the attorney in charge of the matter, but the client authorizes and agrees that other legal parties will help him in this case. So paralegals, secretaries, investigators, associated with the counsel, they may assist Barry Barrister in his legal services. Okay, and by the bottom here, it says by client signing this agreement, client acknowledges having read, understood, and accepted the terms of its entire contract. So before signing here at the bottom, the lawyer and the client, they will come to a common agreement of this contract, and there's no negotiation of this contract. And that's just explaining the basic part of the contingency agreement. All right, and that will be the end of my presentation. Thank you.